Hey everyone, it's Dan Kraus. We're getting ready to start our session talking about planning for Medicaid and how you don't have to lose everything that you worked for if you need nursing care or long-term care. We'll start in a minute or two. Just would appreciate if you could, if you're already in the session, if you just send me a note to tell me that you can hear me. Because I'm not always sure that the voice is coming through, if it's loud enough, and can you see me? Also, there should be, oh good, hearing just fine, excellent. Can you also see that there's video of me, and also what's probably more interesting is the slides. So there should be slides that you can see and a video. You might have to scroll left or right or up and down. Just let me know if you can see the slides. So can anybody see the slide? It should say planning for Medicaid along the top. Okay, Carla says she can see them. Mary said she can see 3 panels. Good. Oh, excellent. All right, beautiful. So here it is, 2:01 p.m. Wisconsin time, and we are going to get started. So thank you for joining us. My name is Dan Kraus. I'm an attorney in Wisconsin. I practice law in the areas of estate planning, elder law, and estate administration, which estate administration just means after somebody has passed away, we help people to make sure that everything gets to where it's supposed to go according to the person's will or their trust or other documents. And so slide number 2, just a little bit about me. My background, I'm very proud of my military service. I served for 21 years in the Army and the Army Reserves and the Army National Guard. Luckily, I was never shot at. I did not have my life in danger, except for sometimes in basic training. I thought I was in danger, but I think they had me back when I was 19. I think I was safe enough at that point. But I'd like to tell a little bit of a joke about the glasses. You see me wearing glasses in the bottom of the picture on that slide. That was a selfie that I took during one of my my tours. It was cold out, so I'm wearing the sweater. But we call those glasses BCGs, and if anybody knows what BCGs is, you can put them in the chat. But that's the glasses that the Army gives you. You have to go in for your annual eye exam, and then they give you these glasses, and you don't get to choose what kind of glasses they give you. That's just the ones that the Army gives you. I see Heidi's a veteran. She knows that BCGs means birth control glasses. Excellent. So birth control glasses just means that they don't have any chemicals in them, but they will stop anybody from wanting to date you if you are wearing those glasses. So that's why they call them BCGs, birth control glasses. All right. Another thing, I am an author. I've written a book called Estate Planning in Wisconsin, Privacy, Protection, and Taking Control. It's a short book. It's about 90 pages, but it has a lot of the basics and stuff about estate planning. Many of my clients have found that it's been very useful. You can get it on the internet, on Amazon. Just do a search for my name, author, estate planning, and you can find it. I think it goes for $14.95. We, as a firm at Kraus Estate Planning and Elder Law Center, we have 3 locations at this time, and we have many accolades and affiliations that we've garnered over the years because we focus on this area of planning. Like I said at the beginning, we don't do divorces. We don't do bankruptcies. We're not going to help you with any mesothelioma type things. We just concentrate on estate planning and estate administration, so we know what we're doing. So let's talk a little bit about long-term care. As I think many people are aware, long-term care is a risk as we get older, and the fact is that if you reach the age of 65 these days, statistics say that you have a better than 50-50 chance of ending up or spending at least some time in a long-term care facility. And if you make it to 75, that percentage increases, etc., as you get older. Some of the dangers of getting older are things that cause you not to be able to take care of yourself. Here's a list of some of those things, some common reasons why people, as they get older, have certain ailments and then they cannot take care of themselves, and then they need some sort of assistance. Many people can't get that assistance at home, or they get to a point where home-based care is just not practical. The people around them don't have the abilities to take care of them. Sometimes they don't have the strength or the patience or just the knowledge to take care of somebody. So what does it cost if you need to have somebody and pay somebody to take care of you or help you? Well, home health aides, if you're going to get full round-the-clock care, you're going to need to have at least 4 full-time people or 3 full-time people and a substitute, so that people can take vacations and have days off and weekends, etc. So if you got 3 people that work 8 hours a day, 5 days a week, you've only got 5 days covered, because 8 times 3 is 24. You're going to need a 4th person to cover weekends, etc., and take over. Anyways, that's going to be over $260,000 a year, probably, if you wanted that type of care at home. And that doesn't include the medications and the equipment and other things that you might need. Assisted living does include meals, typically, and room and board. So there's some benefit there, but that's going to be $5,000 to $12,000 a month, depending on the type of care that you need and the facility that you choose. And a nursing home averages over $156,000 a year, or $13,000 a month in Wisconsin. And it's more expensive and less expensive depending on the community that you have and the facility that you choose. And costs like that go up annually according to inflation, oftentimes faster than inflation. All right, who pays for long-term care? So there's a big cost. So who's going to pay for that? Well, it's a surprise to some people to find out that Medicare does not pay for any long-term care. Let me say that again. Medicare does not pay for long-term care. Now, some people say, well, it'll pay for a nursing home. And that's true. It will pay for a nursing home, but not if you're getting long-term care. They will pay for recovery, rehabilitation, but they won't pay for the nursing part of it, the ongoing long-term care part of it. I misspoke there. They will pay them for the nursing part, but only if it's related to recovery and recuperation. But they won't pay if it's long-term care, and they'll only pay up to 100 days. And you have to meet these qualifications. You have to have been in the hospital at least 3 days, and then move directly from there into a licensed nursing facility. And then they will pay up to 100 days as long as you keep recuperating, as long as you get better and better and better. And then they check on you every week. And if the staff says, no, you've stopped getting better and now it's just a maintenance, they're trying to make sure that you don't lose abilities, then they'll say, okay, now it's long-term care, we're going to stop paying. So they won't guarantee 100 days. Medicare will not pay for long-term care. Health insurance, your normal health insurance, your Medicare supplement, or if you have insurance from your work that's gone on into your retirement, that will not pay for long-term care. It will not. There is special long-term care insurance that you can get. Usually you have to buy it in your 40s or 50s for it to be affordable. Some people can get it in their 60s or 70s, but not if you've had a family history or a personal history of having any problems with your health that might lead you into nursing care. They will not insure you, or it will be too expensive for you to afford. VA pension will pay some nursing costs, but it doesn't pay for all of them. So essentially what that does is sometimes delays or just extends the amount of time that you can pay on your own, but it won't pay all of it. So you still have to pay some of it. Now, the big one is Medicaid. Medicaid will pay for nursing care, but the problem with Medicaid is that you're not qualified, probably. The only way you can qualify is if you have very limited assets or legally countable assets. So in the end, bottom line is you pay until you go broke, and then Medicaid pays. That's the unfortunate circumstance that we have. So some people ask me, well, I guess if that's the system and I'm supposed to use all my money to pay for my care, then that's the only right thing to do. I've got to just get rid of all my money and pay for my care. Well, the way that they want you to get rid of your money is to pay for your care with it until it's all gone. And I don't think that that's fair. People who have scrimped and saved and paid for their home, now they've got their home paid off. They shouldn't have to lose the home. They shouldn't have to lose their retirement accounts. They shouldn't have to lose their nest egg and watch it all go away so that they have no security, no home, no assets at the end of life, and that their kids are not able to inherit anything from them. And the problem with this is that there's a discrimination in the healthcare system, a discrimination that makes it so some people can keep all their money and some people have to go broke. Now, the discrimination is not based on race or religion or national origin or anything like that. The discrimination is based on what type of care do you need? Do you need inpatient and outpatient care? Medicare is going to pay. You don't have to go broke. Do you need long-term care? Medicaid will pay only after you've gone broke. Now, what determines whether you need long-term care or inpatient and outpatient? Well, it depends on what type of illness you have. Now, that's why the discrimination comes in, is because people don't choose their illness. If you just happen to be an Alzheimer's sufferer, now your treatment is going to be in a nursing facility and you have to go broke. If your ailment happens to be cancer, well, you get to have treatment throughout your life and perhaps even millions of dollars of treatment paid for by Medicare, and you don't have to go broke. Your kids can inherit everything that you've saved. So who chooses cancer over Alzheimer's? Nobody. You don't get to choose which ailments that you get. But the thing is, if you had to choose one or the other, I know which one I would choose for purely financial reasons. I would choose to get cancer. Now, I don't want to boogie myself or anything like that because I don't want cancer. But certainly if I was going to choose between those two, it would be cancer. So on this slide, I just show some of the things where Medicare will pay for you and you don't have to go broke and your kids can inherit from you. And you can keep the house and your hunting land up north. And on the right-hand side, you go broke if you just happen to get this. That's discrimination, and it warrants the fact that you should do everything that you can to plan so that you can take maximum effectiveness and maximum security using Medicaid to help you without losing everything in the process. So first, now let's talk about the government's plan for you. So if you need long-term care, if you have Alzheimer's disease, for example, the government's plan is you spend all your money on your care. You spend down and spend down and spend down. Now, they'll let you stop spending once all you've got left is $2,000, one house that is your home, and a car. Now, if you're renting out that house to somebody else, they don't consider that to be your home. Then it has to be sold and the money used for your care. But if you're not renting it out, and it is actually someplace that you live or you have lived until you moved into long-term care, they'll let you keep it for your lifetime. But they won't let your kids keep it, unfortunately. So once you've died, there is what's called estate recovery. This is the second part of the government's plan. So many people say, well, if I can keep my home, that's fine. I'm okay with just my kids getting the home. And so I'll just spend all the rest of my money on my care. The problem with that is once you've spent all your money on your care and you go on Medicaid, then they keep a tab. They say in this month we spent this much on you, and this month we spent this much on you, and after all the months that you had care, this is the total bill, and now we're going to take your house to pay for that. That is the bad part about keeping your house and expecting that that's going to work out. So we already talked about the cost of nursing care. So I do want to mention the long-term care insurance, and I did briefly mention it before. Some people take out long-term care insurance to help pay for stuff, policies that may have been gotten, let's say, a long time ago, 80s, 90s, 2000s perhaps. Typically will pay about $100 a day, which these days is really nothing. It'll only pay for about a quarter of the cost of nursing care. But more recent policies are more expensive, obviously, but any policy is better than no policy once you need it. However, any policy might be just too expensive for you to afford, but you should look into it anyway, because it might be affordable. And if you have any influence over your kids, you should encourage them to get long-term care policies when they're in their 30s or 40s, when it's affordable, and then not to let them lapse. Okay, now let's just have a little bit of illustration. Here's the government's plan once again. Let's just say Dad, this is an example for a person called Dad. Dad has a home. Well, let's say his home's worth about $300,000, and he's also got a $300,000 nest egg or investments, etc. And Dad needs to go into a nursing home, and unfortunately for Dad, or fortunately, whichever way you look at it, Dad lives a long time, and Dad is in the nursing home for maybe even 20 years. So he's gone through all of his $300,000 nest egg, and then he goes on Medicaid. Now the home is still there for his lifetime, but then after he dies, his home is recovered to repay the Medicaid expenses, and his kids get nothing. Unfortunately, once he's done spending down all of his nest egg, he also has no security during his lifetime unless that home is sold, and then he's got some cash. So essentially, at the end, he is completely and totally just reliant on the government, and that is not a good place to be for anybody. So the government's plan does not have to be your plan. It does not have to be your plan. You can have your own plan. And your own plan should focus on you and your family, and not providing for the nursing home or saving the county any money. So that's where elder law comes in. Elder law focuses on knowing all the rules. The rules are very many and they're complicated, and it took me years in order to learn all this stuff, and still I don't know it all. But I know enough that I can help people to save hundreds of thousands of dollars every year through these types of plans. Oh, I do want to mention, you have to have a trusted adult family member to really be able to do this type of planning. And it's usually a child. They should be younger than you are and able to watch after your stuff, that you trust them enough that you would allow them to have control of your finances, or at least a good part of your assets. So the smart plan is to keep the house for your kids, or the farm, or a business, or bank accounts, etc. And then use Medicaid to pay for your care. So with the rules as they are and the government's plan, how do you do that? Well, there's certain concepts that you need to know. And one of those concepts is divestment. Now, if you give any assets away, the government doesn't like that if you then apply for Medicaid. So what they did was they put this 5-year look back period on any gifting or divestment, they call it. They say you're trying to avoid paying for your own care. If you give stuff away, we're going to penalize you. So any gifts given, now any gifts, I'm talking about any gifts, there's no de minimis gifts. You may have heard of an $18,000 or $15,000, $16,000 exemption rule that does not apply to Medicaid. So any gifts, anything that's given for less than fair market value. So selling your home for $1,000 doesn't work. It's still a divestment. It's a sale, sure, but it's mostly a gift, and the government recognizes that. You can't say, well, I sold it. If you sell it to your kids for $1,000 or $10,000 or $100,000, it's still a gift if the house is worth more than that. Now, some gifting is allowed. You can give as much as you want to your spouse, which doesn't really help all that much in most cases, because all of your spouse's stuff is accounted the same as your stuff, as everything you have to spend for your care. Also, you can give to disabled child, or you can give to yourself in a special needs pooled trust. Also, you can give to an irrevocable trust. And sometimes we use irrevocable trust. In fact, we usually use irrevocable trust because it's much better than giving directly to your children. It saves them a lot of taxes, and it makes things a lot more secure just in case something happens to your child in the next several years before you pass away. God forbid. So if you do a pre-plan, and we can't talk about all the intricacies of doing this type of planning, because we'd be here for a couple of weeks just giving you law school lecture type stuff. But as an example, so let's say dad decided, instead of going with the government's plan, he's got the same assets now, but he's going to have his own plan. So he's still got the $300,000 nest egg that he starts with and his $300,000 house. But he's fairly healthy right now, and he wants to do some planning so that he doesn't lose these things. So he figures that he's got 5 years, at least, probably, until he might need nursing care. So given that, he says, let's do some pre-planning. So what he does is he takes $225,000 of his $300,000, and he puts that in a trust, an MAPT, an irrevocable trust. We call that an MAPT. And the MAPT is watched over by his daughter. The daughter is the trustee in this case. And he also takes his house and he puts the house in that MAPT. So now legally, the daughter is in charge of the house and the money, but she understands that if dad needs that back, she's going to take it out the back door and give it back to dad. Okay, so this is the trusted family member. This is where you really need to have that trust. And the rest of the assets, the $75,000, dad keeps in his bank account or investments or whatever he wants, so that if he needs a new roof on the house, or he wants to take a cruise, or if he wants to just have some mad money, he's got that in the bank. He keeps that for his own use, that he doesn't have to worry about taking that out of the protected trust in order to use it. Never put everything into one of these trusts. You always want to keep something out so that you don't break the trust. You just don't want to do that. And then after 5 years, dad needs to go in a nursing home. So as you can see on the right-hand side, dad takes him and his $75,000 and goes into the nursing home. Now, he probably spends some of that $75,000 on a prepaid funeral before he goes into the nursing home. Maybe he takes part of that money and he upgrades his car at that point, because he can still keep a car. He buys a nice car that he always wanted, and then he goes into the nursing home. The rest of it is still under control of his daughter. That $225,000 plus the home, it's been 5 years. Both of those things have gained interest and value. So you probably got really more like a $350,000 or a $380,000 home, and about $320,000 worth of investments if the stock market's done halfway decent during those 5 years. And that is held for dad. Now, daughter takes some cash out of there to give dad some money to get his hair cut, to have massages at the care facility, and to take him out of there, to take vacations, to get him the big screen TV that he wants, etc. And then after dad dies, all of that that's still in the trust goes to the children's inheritance, and the state cannot collect against it to pay dad's debt. Now, the difference between the government's plan and dad's plan is $525,000 plus interest to the kids after dad dies. Much better plan, I would say. A difference of $525,000, and I don't know that anybody wants to give that away. Now, if dad started planning when he was sick, that's what we call a crisis plan. If dad needs Medicaid right away, if he needs nursing care, if he needs long-term care, if he needs assisted living, if he needs memory care right now, it's time to do a crisis plan. It's not too late. People think, oh, once somebody goes into a nursing home, it's too late. It's not too late. It's only too late if dad has lost his capacity and he's not done a proper, powerful power of attorney document. That makes it too late. Then you just have to watch the assets dribble away. Also, if dad's on a guardianship, if dad's under a guardianship, not much you can do. It's just all going to go away. But as long as dad has a good power of attorney, then his kids can do this for him. Or if he still has mental competence, he can sign a power of attorney at the same time he's doing this crisis plan. So what happens in a crisis plan? Well, we don't have 5 years, so we can't save as much. We need to get dad's assets separated, and then he's going to get a penalty because of the divestment. He's making a divestment, gifting into this MAPT right away, and then he's applying for Medicaid. So they're going to say, well, you qualify for Medicaid because you're penniless, and you qualify except you made these disqualifying gifts, these divestments, and so we're going to assess a penalty against you. Now, the penalty is calculated according to how much you give away, about $10,000 per month. So if you give away $375,000, you're going to be disqualified from receiving Medicaid for for about 37 months. So in this case, dad did, so what dad did was he put his home, a $300,000 home plus $25,000 into the MAPT. Now, I'm not saying that this would work for everybody. The factors that depend on how much you can put into the MAPT depend on how much is your care cost, how much is your income monthly. Okay, those two things are going to determine how much you can save. So if your care cost is high and your income is low, you can save less. If your care cost is low and your income is high, you can save more. In this case, dad's calculations came out so that he could put $325,000, including the value of his house and $25,000 into this MAPT, then apply for Medicaid. Now, at the same time that he put the money into the MAPT, he took the rest of it and put it into a very specialized type of annuity. Now, Medicaid does not recognize most types of annuity, but if you have a Medicaid compliant annuity, it's specially formulated so that Medicaid does not consider it an asset, but it considers it income. And as it comes back to dad over the next 32 or 33 months, it comes back in amounts that is enough to pay him for his care through the penalty period. So that's the trick. We get the annuity to pay us through the penalty period. At the end of the penalty period, we've calculated that the annuity stops. There's zero left in the annuity. So all that $275,000 is lost. It's used to pay for dad's care. But that's the sacrifice we make in order to save the rest. Okay? So then in this case, after everything is said and done, dad is qualified for Medicaid, and Medicaid pays for his care. And the family gets to keep that house plus $25,000, the $325,000 for family. That's still way, way better than the government's plan. So I want to reemphasize, if you're in a nursing home or if somebody you know is in a nursing home and they still have at least about $150,000 left, it makes sense to do this type of planning. Save something for the family, save something for their security during their lifetime. Don't just watch it dribble, dribble, dribble till there's zero. Okay. So just if it's not obvious enough, people who don't plan and have bad luck with the nursing home, they end up with nothing in the end. Their kids get a cardboard box and that's it. But if you plan well, you're going to be dressed well. You might not know where you are, but you're going to be playing music in your nice headphones, and hopefully you're going to be happy and comfortable where you are getting your care taken care of. Now with that, I will take time and take any questions that people have. So Laura is monitoring the chat, and she has, I think, identified the questions that I can answer. So I'll go to the questions and see. Okay. So how, if it is irrevocable, does she take money out for him? All right. So that's interesting. An irrevocable trust just means the trust provisions can't be changed. It doesn't mean that you can't take things out and put things in. In fact, your daughter, if you put her in charge of the trust, can take it all out, or she could leave it in and change it from stocks and bonds, and she can invest in real estate. She can put it in cash. She can do all that stuff with this, just like a person could with their money, only it belongs to the trust now instead of a person. So we put a back door into these trusts. Now, I'm only talking about the types of plans that we do. I'm not talking about the types of plans that other people do. I don't know how all other attorneys do this, but when we create these irrevocable trusts, we put the back door in, and then we advise the people, if you need to get money back to dad, this is how you do it. You have to take it out, you give it to dad's descendants, and then the descendants hold it for a week, and then they gift it to dad as a gift. So that's the way you can easily get things in and out of the trust, and that's that. All right, I'm going to mark that answered. Let me go down to the bottom. Assume your options for places are then also limited by Medicaid. Yes, that is true. Let's talk a little bit about Medicaid and what types of places Medicaid will pay for. Now, nearly all long-term facilities will accept Medicaid. Let me say that again. Nearly all long-term facilities will accept Medicaid. There's only a few that refuse to accept it. Now, those few that refuse to accept it are generally the top of the line, and they're not going to let anybody in there that doesn't have at least $2 million showing on their balance sheets, okay? Because they want to know that that person is going to be able to private pay for their high prices for the foreseeable future, forever, in fact. So that's only for people who are like at the top end of the spectrum and can afford to pay for their own care. Every other facility takes Medicaid, no matter what they tell you. Now, most of them will not take Medicaid from day one. Most of them have a private pay period that they enforce. Now, the private pay period, they will tell you that you have to private pay for 24 months or 36 months. Sometimes it's 48 months, but it depends on the facility. They make the rules. They say, we will take Medicaid on your behalf if you are private pay for at least X number of months. So it's usually 24. More often these days, I'm seeing 36 months. But that's the rules. So you work within the rules. When you do your plan, you plan to have enough so that you can pay through that private pay period. So whether you need to pull money out of the MAPT to get you through that private pay period, or what you need to do, you just factor that in. And if it's an issue, you just save a little bit less, right? So in Dad's case, he saved $525,000. Let's say he needed to use $125,000 of that to get him through the private pay period. Well, then he saves $400,000, but it's still better than nothing. So yes, good point. Your options are limited by Medicaid, but not as much as you might think. If you need Medicaid from day one, yes, your options are going to be very limited because there's only a minority of places that will take Medicaid from day one, but the majority of places will take Medicaid if you've been private pay for at least a certain amount of time. Good question, thanks. Does my revocable trust serve as my Medicaid trust? No, it does not. Unless, well, they changed the rules in 2014 so that if you have a trust that was created before August 1st of 2014, and you put your house into that trust before August 1st of 2014, and you did not change the trust since then your house can be protected from Medicaid recovery. Everything else that's in that trust is not protected. So you cannot use a revocable trust as a Medicaid trust because the fact that it's revocable means that the government, the county, the state can require you to spend everything within that trust before you qualify for Medicaid. They do not see it as any different than having it in your pocket. Okay, what if you don't have the appropriate trusted adult in the U.S.? That is a serious problem, and it has caused some of my potential clients just to say, I can't do this. If they don't have any children, or they don't have any children that they can trust, they don't have any other trusted individuals, then you just can't do this type of planning. You cannot do this type of planning with an institutional trustee. You can't use a bank trustee. They will not work with you just in case you need to get assets out of there. They might agree to be your trustee and hold on to those assets, but if you come against a rock and a hard place, they will follow the terms of the trust precisely and not work with you to get the assets out of there, whereas your family members can use the trust and the back door, which institutions will not agree to do. You mentioned in the U.S. Now, if you have a foreign trustee, like your child is out of the country, that's not necessarily a problem. It depends, and we should talk about it if that is the issue. If you've got a trusted person, but they are in another country, that might work. I'm interested in how these spend down policies affect an at-home spouse, or when one spouse is in long-term care and one is not. That's a very good question. The spousal rules, there are rules that prevent complete poverty of what we call the community spouse. The community spouse is the spouse that's not in the facility. They're still in the community, living in their home or wherever they live in the community. The rules are that the spouse is allowed to keep a certain amount of the resources, the assets, and they're also allowed to keep their 401k and their IRA without spending those. If this is a situation, if one spouse needs long-term care and one does not, you need to get professional opinion on this very quickly and get somebody working on that so the community spouse can preserve the maximum amount of assets for them and their security during their lifetime. Otherwise, we've seen uneducated spouses just spend everything on the care of their spouse when they didn't have to. Typically, we can save everything for the community spouse if the other spouse needs care. So that's something that you really need to get professional help on. But yes, there are some rules that allow the community spouse to keep a certain amount of assets. They don't have to spend down to $2,000. It's more like $154,000, but still, that's not a whole ton if you start with $500,000. So get professional assistance on that to maximize the community spouse's available assets. All right. What if assets, including home, held jointly now? So that's typically the case. I mean, if you have joint assets, depends on whether it's with your spouse. If you have joint assets with your kids, the the state is going to assume that those belong to you, and you would have to prove that your kids actually put money into that joint account if it's joint with your kids. Most people can't do that. And if the kids put in like $500 and you put in, $80,000, that's still your money that you have to spend down for your care. Also, same thing with the house. So joint assets are a complicating factor. Depends on the asset, depends on who it's joint with. Okay, what if assets, okay, hope I didn't skip a question. Can I make an estate plan without my husband? We are separated and he does not negotiate in good faith. I am sorry to hear about this situation. It's a very frustrating one, and it's difficult to do a plan without your spouse. Depending on whether you have a separate marital property agreement, or you have some sort of marital settlement agreement that says, this is my property and this is your property, you can do some planning without your spouse, but it's hard to save really much of anything. And the sad thing is, if your spouse ends up in a nursing home, they are going to take your assets to pay. And if he's not cooperative in this type of planning, you may lose out. I don't presume to tell anybody what to do with their lives and who to be married to and who not to be married to, but sometimes divorce is really in the best financial interest of people. I don't know your situation, so I don't want to presume to suggest that. Okay, do you have to have a trusted family member to put an irrevocable trust? I have no children and would like to use a friend. Now, it doesn't have to be a family member. A friend would work. It would work in all the same ways that a family member would work. One of the issues, though, with a friend is usually a friend is around your same age, and they are going to get old at the same time that you are going to get old, and that makes it a little shaky. You would have to have more than one that you could put alternates on there, so that you know that if your friend needs a nursing care before you do, or if your friend dies, or something, they move away, or you have a fight and you don't talk anymore, you need to have other people that are there that are going to be there. That's why family members, you can't just move away from a family member. You can't say we're no longer family members anymore. It's they say blood is thicker than water. Makes a lot of sense, but it is. You can have a friend do it. I'd say it's risky, but it's up to you. Another piece of the puzzle. What if we decide to go into a CCC community that requires an endowment? Then that amount would not be shielded if someone moves from assisted to long-term care levels. Continuous care, right? Continuity of care, or I think that's what the CCC means in that case. Yes, those places that require you to put $200,000 or $300,000 down, and then they give it back to your family when you die or move out. They give 90% back or 85% back or whatever it is. Those, unfortunately, you can't save that. That money that's coming out is going to go to repay Medicaid, and I don't like those arrangements for that reason. Now, I know several people who love the care that they get and the security that they have in these facilities, but for Medicaid planning purposes, I don't like it. Okay, how often do these laws change? And then I need to make adjustments to these changes. Well, Congress never tells you when they're going to change things. How often do they change? There was a big change in Wisconsin in 2014. Since then, there have been small incremental changes, not much that really needs to be mentioned, but that was 10 years ago. They've been talking about changing the look back from 5 years to 7 years. Every now and then it comes up. They haven't done it. As you know, Congress is hard pressed to do anything useful or anything at all, really. So I don't know. If you're asking me to tell you whether they're going to change stuff or when they're going to change it, I have no idea. I have no idea. I just know that these types of plans help people out, and I've seen it work. But Congress could just probably take all this away from us without notice. I will tell you, most of the times when they make these changes, they are grandfathered in. So if you've got a trust and you've already transferred something, then you're good. But if you haven't set up your trust yet, then you would not be grandfathered in, and you'd have to go by the new rules. Will you be doing a seminar for unmarried couples? I'm 69, my boyfriend is 66, and we've lived together for over 40 years. That's a good idea. I'm not sure how much interest we'd have in a seminar for unmarried couples, but we do come across complicating cases like this a lot, where families are, after death of somebody, families are fighting with the boyfriend, the long-term boyfriend or girlfriend or, partner. And these cases used to be more common when we didn't have same-sex marriage, where you'd have long-term same-sex couples, but you still have long-term heterosexual couples or any long-term couple. And it's complicating. If you don't have a plan, if you don't have a written plan, they are going to be completely left out of your estate. But another thing is, if you're not married, then their assets are not included. If you need long-term care, they don't have to pay. And vice versa. If you need long-term care, they don't have to pay for their assets, only your own assets if you're not married. I don't know whether we don't have one plan for unmarried couples, but it's not a bad idea. And we will discuss it after this. And if you're on our mailing list, we'll let you know. What is the ballpark cost to set up this plan on $1.5 million in investments and $350,000 home? That is a great plan. We always get the question about cost. It doesn't depend on the amount of assets that you have. It depends on the types of protection that you want. And we go through that in a private session where we talk about what are your assets, what are your aims, what does your family look like? And then we'll say, if you want this level of protection, it's going to be this much. If you want this level of protection, it's going to be that much. And if you want a basic plan, it's going to be this much. So I can tell you that the range starts at around $2,600. That's a single. So like $3,200 for a couple. And it goes up from there. And a very protective plan is going to be over $10,000, but it all depends on the choices that you make and the levels of protection that you want. But as you can see, the numbers that we went through here, where a family saves $525,000, is not unusual, really, with this type of planning. Also, we didn't even mention the tax savings of capital gains tax on your home if you do this planning with trust instead of just giving the home to the kids outright. Okay, if a descendant takes cash from irrevocable trust and holds it a week, then uses it to support dad, isn't that then deducted when Medicaid reviews? That's not considered income. No, it's just a gift from the child to the parent. It doesn't cause any kind of problems with Medicaid, as long as the assets, it's going to count on dad's balance sheet. If you give dad $10,000 and he has it in the bank, they're going to say, well, you're no longer qualified for Medicaid because it's over $2,000. So you got to be careful. If you give dad, let's say, a big screen TV, or you get 8 of them and put them all the way around his room so that he can see things in surround vision, that's not a problem because he doesn't have it in his bank, and he can have as many gadgets or things for himself, as long as for himself to use. So that wouldn't be a problem, but just putting it in his bank account could be a problem for him. All right, let's see, 2:49. We still got 10 minutes. Okay, I guess what I'm asking, if we were to plan this in advance, 65 and 64 couple, do Do we have to know in advance if we will be deciding to go into a multiple level continuing care facility? You wouldn't have to know. No, because the way that we set these plans up, as long as you have a trusted person, you can ask them or tell them, look, we need the money to pay for this multiple level continuing care facility. We have to put down the down payment or whatever they call it. We have to buy the spot. And so then you can change your plan at that point. So nothing's written in stone as long as your trusted person does what you want them to do with that. So if you set up a plan now and later decided that you need to take money out to put it into one of these multi-level continuing care facilities, which many of them are very good as far as the care goes. I just have a problem with it because you can't save the assets as much. So yes, you can undo what you've done. You can make it work for you if you plan now. You don't have to decide. Okay, so community spouse keeps its own 401k and IRA totally separately from pay down. Yes, that's true in Wisconsin. And this rule is different state to state. So be careful. Most states count both IRAs and 401ks. Wisconsin only counts the IRAs and 401ks of the person that needs care. Okay. Other states don't count IRAs and 401ks at all. So you just have to be careful which state you're dealing with. So I'm talking about Wisconsin. The person whose IRA it is does not have to use it for the other person's care if you're married. So it doesn't count as the pay down. Right. Okay. Not all long-term care facility care ends in death. That's true. Can you address a situation where a person may need long-term care, but then be able to return to independent living and have to pay rent? I'm not sure what the question is, but that's true. You could be in a long-term care facility and then downgrade into assisted living or independent living. If that's the case, then you just use your income because you're going to get your income for your whole life. It doesn't stop. You use your income to pay the rent. If your income is not enough to pay the rent, luckily you had money put aside in your MAPT so that now your kids can take that out to supplement whatever you need to pay in rent. If you had just kept everything out of your MAPT, you might have spent it all on your nursing stay and now you've got zero left. So if you need to then move into independent living, you got no options. So it's best to pre-plan, put money aside, and then you'll have options to downgrade your health care. Whereas if you've already spent it on your nursing care, there's no option. You either stay in nursing care or you go home. If you have a home at that point. All right. Can you have two trusted persons? Yes, you can have 2, 3, 4, 5, 6. There's no limit. I mean, more than 2 is probably a little sketchy. I see 3 every now and then where people want all 3 kids to be in charge of that. And that's fine as long as they get along and as long as there's no fights and they all agree to do what you tell them to do, then I think it's a great situation. But you don't always have 3 people getting along or even 2. But yes, 2 people, certainly you can have 2 co-trustees, and now your son and your daughter work together to manage your assets, the ones that you put in the MAPT. All right, so we are 5 minutes to the hour. That is the last of the questions that I see. I hope I didn't skip any questions. I fear that I may have clicked off on one before I got a chance to answer that, but hopefully not. Let's see. Can anybody tell me, did you ask a question that wasn't answered? We've got a couple of minutes left. I don't want to feel like I'm dodging any questions. I want to try to provide as much help as I can. So we'll wait about 20 seconds, and then at that point, we'll sign off. But I hope that this has given you some things to think about, some education on this, debunked perhaps some myths that you've heard. And I see one question. What happens if the trustee dies? Great question. If the trustee dies, then you need another trustee to go in there. Now, if you've only named one, which we never recommend, you should always have at least one, and better to have 2 or 3 alternates, so that if one can't do it, the next one takes over, etc. But if you end up with no trustees in your trust, then you have to have a trustee appointed, sometimes by a court. So there can be another trustee appointed, but sometimes it's a pain to get that done, which is why we always like people to have at least 2, and 3 is better. So alternate. Okay. Thank you, everyone. I really appreciate you showing up and coming out and learning a little bit about Medicaid planning. If you're concerned with Medicaid planning, please call us and make an appointment. I would be happy to talk with you. Before you can meet with me, I will need to have you fill out a form telling me about your finances and your family situation, so that I can be prepared to address your particular situation, because there's limited time that we have to talk. So I want to be able to get right to the meat of the business and see what we can suggest for you and your family. And I hope to goodness that at the end of life, you and me and all of us are happy as this guy, listening to his music in his nice suit. Although it probably better not to be wearing a suit, just because they're not that comfortable. All right, everybody. Thanks again, and take care. If you're still here, I don't know if you're the one that asked that last question that just popped in. Would we work with me or with another person? Everybody who would make an appointment worked with me from this office. I am the person that does this type of work. So you would be working with me and the rest of our staff, but I would be the one supervising the work. Thanks for the question. Now I'm going to sign off. All right. Thanks again.